Hey friends, I have an important update to share with you in this one, and it's about how USCIS will use more discretion in certain cases that could potentially lead to more denials of cases. Let's talk about it. This update changes how immigration officers decide certain cases when discretion is involved. And trust me, this is something you need to know about before you apply. So what's this all about? Let's break it down. The role of discretion in immigration cases. For many immigration benefits like adjustment of status, extensions of stay, or even employment-based petitions in certain cases, it's not enough just to meet the basic requirements. USCIS officers also look at whether you deserve a favorable exercise of discretion. That means they will weigh the good and negative or bad factors in your case before approving it. New negative factors, terrorism, and anti-American ideologies. USCIS has now made it clear that if someone has supported, promoted, or endorsed terrorism, anti-American activities, or anti-Semitic organizations, that will carry very heavy negative weight in the officer's decision. In plain terms, if you've been involved in any of that, it's going to be almost impossible to get an approval of your case. Compliance with the laws matters. Another change is that USCIS will now look very closely at how you filed your application for admission or parole into the United States. If you follow the laws and rules in place at the time of your application, that's a good factor. But if you didn't, that could hurt your chances of being approved. For those of you with an employment-based petition, listen up. USCIS clarified that discretion only comes into play for national interest waivers. For most other employment-based cases, discretion is not a factor, but for EB-5, the investor process, discretion will definitely apply if there are signs of fraud, misrepresentation, criminal activity, or threats to national security. Now, for student visas and other non-immigrant benefits, the update also confirms that USCIS uses discretion in cases like extensions of stay, changes of status, or reinstatements for students in F or M visa categories. So if you're applying for one of these benefits, friends, your overall conduct and immigration history will matter. Lastly, where exactly will these changes appear? This new guidance is officially added to the USCIS policy manual in several volumes. It's effective immediately and overrides any prior policies that were in place. So this is in effect right now. To sum it up, USCIS is tightening its rules around discretion. Again, like I said at the very beginning, when they do something like this, most likely it's going to lead to more denial of cases. If you've been associated with anti-Americanism, which I've talked about in another video, or terrorist organizations, that's almost always going to mean a denial of your case. On the other hand, if you followed immigration laws and have strong positive factors, that can help balance your case. For employment-based petitions and investor petitions, discretion applies in very specific ways, especially if there are fraud and national security concerns or issues. Friends, if you're filing for an immigration benefit and you're worried about how these discretionary factors might affect your case, don't take any chances. Contact us at McBean Law for us to review your case and look to see what's going on so that you could put your best foot forward with immigration. Friends, things have gotten very serious with immigration. Subscribe to this channel so that you don't miss any of my updates each week. Comment below and let me know your thoughts about this issue. Again, with more discretion given to these officers, the likelihood of case denials is much higher than before. Thanks so much for watching, and I will see you in the next one. Bye-bye.